Welcome back to the Legal Weekly Wine. I am your host, Virginia Tehrani of Tehrani Law LLC, because you never need a lawyer till you do. And this is brought to you by The Law Unscripted. We handle for the Legal Weekly Wine the hottest legal topics of the week. And this summer is truly hot. We have Supreme Court decisions, because it's June, coming out like crazy. And even today, Friday, we have got the last Friday of the month. We've still got Supreme Court decisions that have come down today. So we are going to hit the ones that have come down prior to today in our podcast today, and then pick up next week, where we come back for all of the ones that have been decided today or brought down today. Published today is probably the best word on this Friday. So I have with me our illustrious co-host and guest again today, Dr. John Weil from Middle Tennessee State University. He's the Dean of the Honors College and a longstanding professor of political science, as well as an expert on the Constitution, the amending process, and constitutional law. So thank you for joining us today.
It's a pleasure.
Oh my goodness, it's been so good to have you on our summer session of the Legal Weekly Wine, especially to help break down the Supreme Court decisions that are coming like hotcakes, it seems.
There have been some doozies.
They have. They are definitely not any kind of cold cakes. They are truly hot cakes. And I thought last summer was pretty monumental with the Roe versus Wade type of decision, however you want to say it, the Dobbs decision about Roe versus Wade. But this summer has not disappointed in terms of surprises and interest.
It was interesting. Yesterday, President Biden was asked, is this a rogue court? And he says, it's not a normal court. I don't think that's right. It's a little more consequential than some, but I think this time, almost every year, we are sometimes surprised, sometimes pleased, sometimes disappointed.
Yeah.
And I would say, no, there are some aspects of the court, particularly involving judicial ethics, that I think need to be cleaned up this year. Right. But in terms of the decisions, the affirmative action case, for example, yesterday, Chief Justice Roberts has been saying for 20 years or better that he thinks the Constitution ought to be colorblind. And so, yes, there were some, maybe including me, who thought, well, maybe the court will stick with sort of the existing ambiguity. Race can't be determinative. You can't use it. You can't have racial quotas.
Right.
But maybe in considering diversity, you can use it. And pretty much he seems to have closed the door on that.
And this is in, not like anybody doesn't know who's listening, but just so we make sure to do it, this is the Harvard and North Carolina case.
Right. One's a state school and one is a private school.
So it's Students for Fair Admissions versus President and Fellows of Harvard College. And this was based on the equal protection, like you're saying, of affirmative action, where we've had what we call affirmative action for how many decades?
At least since what it was. I should have looked up the Bakke decision. I believe it was 78. I may be wrong.
Yeah, I think it was late 70s. I think 77 or 78.
Yeah, somewhere about the time that I was graduating from getting out of graduate school. And again, that was an odd case in that
the original one.
Right. The original Bakke case, and that you had a 4-4-1 decision where the one justice, his lone decision basically decided that case and cases for the next 40 years. And it was Justice Lewis Powell of Virginia. There were 4 justices who said you can use race to overcome race. You had 4 justices who said considerations of race are verboten. That's what equal protection is about. And Powell says, well, you can use race in the limited situation involving college admission, where you're doing it not just to enable members of that race, but to increase diversity of viewpoints, backgrounds, and the like. And that single, I mean, he bridged the divide.
Yeah.
You can't use, no, he's opposed to quotas. Yes, he favors some use of race, but not for anything. You know, he basically struck down, we're going to use race to provide Black doctors and lawyers, or we're going to use it, et cetera, to no, you can use it for diversity in the classroom. And, you know, one of the fascinating things about yesterday's case is you had a number, you know, race is a very fluid concept. As Chief Justice Roberts pointed out, all Latino, you know, a Latino from or a Latina, I don't know which the proper word is, but one from Cuba may have very different perceptions than someone who's from Mexico or someone from South America.
But that would deal with ethnicity, not necessarily race.
Well,
that
but
portion
that's
of it.
Well, I think,
or would it be?
I mean, the larger point I was going to make is that some of the students in this case are who were opposing affirmative action were Asian Americans who said that it was actually working against them. And as Justice Roberts pointed out, well, to say Asian American is sort of like to assume that everyone in California has the same views as somebody in Tennessee or New York or Texas. It covers a wide variety. And I guess that's, you know, that the difficulty with racial classifications is they tend to rely on stereotypes. And sometimes, you know, I suspect that it's something of a burden to believe that you are in a class or have everybody else thinking you're in a class because of where you came from or who your ancestors were rather than on your merit. I think we mentioned before Justice Thomas, who was a recipient of affirmative action, apparently put a 15% off sticker on his Yale diploma because he said when people looked at him, they weren't sure he really belonged there.
Oh, wow.
So, yeah.
Oh, that's really interesting. So with it, are you surprised by the decision? You've been waiting for it for a while.
Well, I have. And, you know, there's 20 years ago, Justice A. O'Connor basically wrote a decision, I believe it was in the Michigan case, but it may have been in another, in which she essentially said there's a time limit on use of race. And she projected that in 25 years, we would no longer need racial considerations. And one of the things that Chief Justice Roberts points out is there doesn't seem to be any termination. Harvard and UNC apparently as well, you know, had no plans to say at the end of 5 more years, we won't need any race anymore. And he basically argued that the standards for determining when to use race and why to use race are so varied that they're really not subject to judicial determination. Well, one of the things I think that's missing, you know, there were very strident views on both sides yesterday. The exchange between Justices Clarence Thomas and LaTonya Brown Jackson were particularly notable.
Right.
But
and who was it that read their decision?
Well, I think a number of the justices, I think Sotomayor and, I think Roberts, Thomas, Sotomayor, and Jackson all read something from the bench. I may be mistaken on that.
Which is unusual.
Well, it's not unprecedented for sure, but usually justices, you know, you get an announcement by the justice or by the lead writer, and that's about it. But in important cases, it's another way to add a little bit of drama to be heard. But, you know, one thing, I frankly think this case may be getting more attention than it deserves. And that shouldn't be coming from a constitutional law professor. But it's not as though, as disappointed as some people are and thrilled as others are, neither side is arguing from racist assumptions. I mean, the majority is saying we want they're quoting Justice John Marshall Harlan I, who said that in the eye of the law, now I'm going to forget the quotation, but basically all are equal. The Constitution is colorblind, neither knows nor tolerates classes among citizens. That's the ideal that the six in the majority are saying, and those in the minority are not saying, we want to reimpose segregation. And go to Roberts's opinion. He says we were wrong in Plessy versus Ferguson. We were wrong in Dred Scott. We were wrong in Plessy versus Ferguson. We said that we're not going to use race. The dissenters are saying you have, basically that Roberts has a somewhat naive view that if everyone in society is still, or many of us are still seeing issues from the standpoint of race, then we may need to consider race to overcome it. But
and I think that was the biggest issue was we are being naive, is that we still have so much to recover from, that this will set us back.
Right.
Or at least stop progression forward for advancement of African Americans.
Right. But again,
the minority is still less.
To be clear, however, the court had already upheld, I believe it's a referendum in Michigan and perhaps in Texas as well, where the state decided that the state had already said you do not have to use racial considerations in university admission. Now, the response to that is that, well, states that discontinued this policy have found that their African American minorities have in fact decreased. And to the extent that that's a bad thing, doesn't provide the same kind of diversity, then that's a concern. Roberts's response in part is, and I guess Thomas's, if there's anybody on the court who epitomizes the view that you can't necessarily put people in a box in terms of their opinion on the basis of race, it's Justice Thomas. He confounds every stereotype as to African Americans must be liberal Democrats. African Americans must favor quotas. African Americans must do this or that.
Oh, interesting.
And, he's very independent in that respect. Now, you could say that his independence is he's following an equally rigid sort of views on the other side, but he does show that just because you have an African American in the room doesn't necessarily mean that you're going to get a different opinion than if you had an Asian American or a Latina or someone else.
Now, so everyone understands, where did he fall in the affirmative action decision?
I'm sorry, Justice Thomas?
Justice Thomas.
Right. He has a concurring opinion, I believe.
And with the concurring, he agrees with the overall decision of the majority.
He opposes, he has from the beginning. He believes that, as I understand it, that instead of helping him forward, everybody who looked at him said, well, you really didn't deserve to be at Yale. You were there because, you helped, well, not meet a quota, but because of your race. And he says, this is wrong. And to some degree, it's not quite, but it's almost like the ancient division between W.E.B. Du Bois and Booker T. Washington. That's not quite the same, but Washington basically said, we don't need to worry about getting in elite colleges. We need to work our way up, prove ourselves, and in time we'll be equal with others. And Du Bois said, I'm going for the top 10%. They're the people that are going to lift our race up. And so it's almost, and again, perhaps because I'm at a public university where no considerations are given, to, is my understanding, to race in terms of admission. And we have, a good 15-20% of our population is African American. We have other minorities here without using quotas. In some ways, this is a little like inside baseball, and the court is the one area where, the court is more diverse than it's ever been in terms of race and gender.
Right.
It is it's more similar than it's ever been in that, to my knowledge, not a single justice graduated from a place other than the Ivy League. And I'm sorry, William and Mary, I don't know how you ended up not making Harvard or Yale.
Right. The two of us, both William and Mary graduates, you for undergrad, me for law school. We're failing, Dad.
I know we didn't make that top elite.
We didn't.
And by the way, one of the other fascinating things about the current court, for many years, there used to be a Jewish seat, used to be a Catholic seat. Right. Some say there was sort of a Southern seat.
And now Scalia was the Jewish seat, right?
Pardon?
Jewish was Scalia, or no? Gator.
No, first Jewish appointment was Justice Brandeis, and then you had a series: Brandeis, Frankfurter, Goldberg, Fortas. No, I believe I'm not positive about Fortas, but
was it Ruth Bader Ginsburg as well?
Right. Yes. Now, again,
what was Scalia?
Catholic.
Okay, he was the Catholic.
Italian Catholic, right.
Okay.
The Catholics now have a majority on the court. There's only, for many years, there was a Catholic seat. Right now, a majority of there's only two Protestants on the court.
Which ones are they? Goodness, I couldn't say Justice Ginsburg.
Gorsuch, I believe, is Episcopalian. And LaTonya Brown Jackson is sort of non-denominational Protestant.
Okay. Wow. I did not realize. See, here I am behind on the background of the justices, but do you think their backgrounds play a large part of this decision, or do you think it is mostly constitutional based? Can we determine?
They play a part in their nomination. And in fact, I was just working on an essay this last week on Justice Jackson, and I had not realized this when Biden had fallen behind in the primaries. His friend from South Carolina came to him and said, "Will you promise to nominate an African American woman?" And he said yes.
I remember that.
He subsequently won that primary and won the election, and he was true to his promise. Mm-hmm. By the way, I believe Jimmy Carter had promised that he would nominate the first woman if he were
reelected.
Elected. And he never got an appointment in his 4 years.
Right. So you can't just pull somebody and appoint somebody. They have to actually have an opening.
And then Reagan ended up with, being able to appoint the first woman who was Sandra Day O'Connor.
Wow. So Thomas was the concurring, where he said, yes, I agree with the decision, but I have a few different things I'd like to say. And who was on the dissent?
Well, right. Let me make a confession here. Yeah. Because I was writing up the other case yesterday in Groff that I think we're going to discuss. The affirmative action case was 182 pages or maybe even longer.
I haven't been able to get through it all.
And so I haven't gotten through all of it. And I should have it here. But it was a 6-3 division. Mm-hmm. And the three dissenters were Sotomayor, Kagan, and Jackson. So,
and are they all three? Tell me about Kagan. I can't remember. Are they all three minorities?
No.
Okay. Kagan.
No. She may be Jewish, if you want to consider that a minority.
But she's also a woman.
Right. She's. Right. There are three women, but the women were not unanimous. Amy Coney Barrett was obviously for the majority decision. All three Trump appointees were for the majority decision. And he has been sort of trumpeting the fact that, one of the fascinating things about this, if you look yesterday, almost every Republican who spoke out and strongly in favor of the decision. Almost every Democrat who spoke out opposed it. But this may be a gift to the Democrats. If I understand it, 70% of the American people are opposed to racial considerations being used
in school admissions.
Right. Now, what I don't know, and I just haven't had time to research it, I don't know what this says for, although you would think the same principles would apply, I don't know what it says for hiring decisions.
Oh, I was so going to ask you about that. So I'm glad you've brought us there. What in the world do we do?
I don't know. I mean, for example, I'm right now hiring a university advisor. I sent in a list of 4 people, and I got back a list from our employment office of 6 people. And I looked at them, and it looks like it appears as though, that they're probably African American. And they're good. They are qualified candidates, so I'm happy to interview them. But they are getting a plus, presumably because of race. And I don't know if this is like Brown versus Board of Education, where if you don't have segregation one place, you can't have it any, or whether these are going to be separate issues. By the way, there was one exception.
The military schools.
Well, there's another exception beyond that. The court gave one limited case where one could use race, and that is in prisons. That if you were facing,
I missed that.
No,
how did I miss that?
If you were facing a riot in a prison, and you thought that separating people, for example, if you had separate white and black gangs, and you could separate the population in that limited case, the court upheld it. Now, the other fascinating thing about the case yesterday is there a workaround to considerations of race?
Right.
And I don't think commentators have read this case closely enough, even though I say that not having read the whole thing myself. But some of the dissenting justices say, well, this is just on paper. What's going to happen is most schools require essays, and I'm going to say, I am the man I am today because I grew up as a black boy in rural Tennessee, and I had to overcome all kinds of obstacles.
Right. And they specifically point that out in the dissenting opinion.
They point that out. And what Robert says is, be careful not to take the law from a dissenting justice because it might get you in trouble.
That's pretty funny.
So I'm not sure. I'm sure there will be attempted workarounds, but I'm not sure that I know exactly what's going to be acceptable and what's not. And it's when the court decided the Dobbs decision, I think it basically said, we are so tired of looking at abortion cases. Let's send it back to the legislature. I think they're likely to get more cases, if you can do 6 weeks, can you do 3 weeks? And I think we're probably going to have some more affirmative action cases here too.
Well, let me ask you 2 other questions before we close up this topic.
Okay.
One, you mentioned earlier, I know you are at a public university. Middle Tennessee State University is one of the public universities in Tennessee. And you were saying that your school does not use affirmative action. Why is that separate than the schools that came up with Harvard and North Carolina?
Well, now let me make a qualification. When there are some scholarships where we take 20 people and put them in a single class sort of cohort together. And we don't ask about race, but if we see someone who looks like they might have a unique experience from race or ethnicity or country of origin, then we do take that into consideration in, well, this would make a more interesting class. Just as we would, we have a great aerospace program here. Yes. We have a lot of students in pre-law, a lot of students in medicine, but we don't want 20 students in our top Buchanan program, all of whom are pre-med, or all of whom are pre-law or aerospace. So, and that sort of goes to that consideration that Powell used to make about, diversity. But in terms of, overall, for honors college, for example, somebody comes here from as a freshman and they have a 25 ACT or higher, or they have a 3.5, they're in the honors college if they want to be. We get a very good proportion of African Americans and other minorities, but it's not something, that's not how they qualified to get in the program. And the same, most of our scholarships at MTSU, if you have X score and X grades, then you will get this scholarship. If you have a little bit higher grades and scores, you'll get this scholarship.
You automatically qualify for that particular scholarship. Now, are you different? Is there the prior rule for affirmative action, for lack of a better way to say it? Is that distinct between public and private schools, or it was across the board of all schools can do this or should do this?
The first question, notably, we have two decisions here. And by the way, if I can give a shout out to Ketanji Brown Jackson, she recused herself from the Harvard case because she was
from Harvard.
Well, and I think she's actually on, or had been on, one of the boards there at Harvard. So she recused herself from that. And I think that's a great example to set. But, the federal government is so involved in education in terms of Pell Grants, in terms of loans, in terms of financing scientific research, that they have enough leverage on private universities. I think, I'm trying to remember, was it maybe Grove City is one of those few colleges. There was a case 20 years or 30 years ago, I guess, maybe even longer, in which they basically said, well, our students don't take any federal aid. We don't allow. Now, there's since been discussion as to whether that's permissible or whatever. Right. But by and large, both are, the national government has enough leverage because of student aid and other aid to universities that there didn't seem to be a major distinction between public and private in this case.
Okay. And the second part of it is, so everyone is aware, the prior decision did not require quotas. That's right. It was just
no. It's even clearer than that. Mm-hmm. Prior decisions had forbidden strict racial quotas.
Right.
They had permitted consideration of race as a form of diversity, but the court, between Bakke and the Michigan cases and the Texas cases, the court had said no one was required to use race for affirmative action. A state could decide that they were not going to. Again, those states that didn't saw a drop off in the number of African Americans. Some of them may have seen an increase in the number of Asian Americans. And again, recognizing that the term Asian American, that can be Chinese, Vietnamese, Malaysian, a whole host of different folks.
Okay. And then the final question, so that was kind of the college school question. The final question I would have is in going back to the workplaces, to the best of my knowledge, and maybe I just am not caught up on this, is I don't think there's a specific Supreme Court decision with regard to diversity in the workplace.
There have been cases involving contracts that go to minority contractors.
Okay.
And the like.
But no established rule across the board one way or the other.
again, I think that's right. But I think this decision may be a little like Brown in the sense that Brown's, you had previously had a case or two that involved interstate transportation.
Right.
And then you go, finally you get to Loving, where states' interracial marriage laws or prohibitions of interracial marriage laws were declared unconstitutional.
Mm-hmm.
So we may find a ripple effect, not so much in college admission, but throughout, there are a lot of,
right.
There are a lot of private businesses, and maybe they're just trying to be politically correct, or maybe they mean it, that believe that having a diverse, if you go into a bank and everyone there is white and you're black, are you going to be less trustful, less likely to want to put your money there? And, the same might be true of a good deal of professions. So I'm not quite sure what the implications there are.
Well, I'm guessing that we'll have another case or two up through the Supreme Court, and possibly on that workplace question. Okay, well, thank you. So before we get to the next one, we do have the Legal Weekly wine. So I do want to announce our wine today, and in tribute of where we're going and of William and Mary, I've got from Williamsburg the Governor's White today. So this is from the Williamsburg winery. You and I were back there a couple months ago.
Okay, and white is not a racial designation, right?
No, it is not. It is the wine.
Okay.
It is the Governor's White wine.
Okay.
I'm glad you've clarified.
Not wine for whites. Okay.
No, it is the white wine. It is not the Governor's Rosé. It is the white because of that. But I think it's really nice of where we're getting a lot of, the buildup of the legal system was from Williamsburg. Even, from the beginning, right? We had even revolutionary impacts beginning with Williamsburg.
Marshall Wythe Law School, right?
Yes, the Marshall Wythe School of Law.
And we're going to tell the story on me?
Oh, you absolutely should.
About James, right. So when you go to William and Mary, there's this statue of
at the law school.
Right, at the law school of John Marshall and George Wythe. And
the founders.
Right. And in the description of Wythe, it says that he educated Thomas Jefferson, James Madison, and others. And I wrote a letter to the law school saying,
while I was,
I know James Madison, and I don't remember, I played James Madison, and I don't remember studying under George Wythe. And as I recall, and so the letter I got back was, it's not that James Madison, it's Bishop James Madison, who was president of William and Mary. And now you can continue the story in your law school ethics class, right?
Yes. So the question was, should he have been called Bishop James Madison so that he was distinguished? Because it was a little bit misleading.
Yes.
In how it was presented. So a lot of our students are saying, oh, James Madison studied under George Wythe. And we had this, there's always the question of who had the first law school. We're in a constant debate. But yes, the dean at the time, Dean Taylor Reevely, who I absolutely love, future president. So he went from dean of the law school while I was there to president of William and Mary. And I believe now he's retired. But it was interesting because I was in law school at the time this letter happened. So what did happen with the ethics? I'm not entirely sure.
I recall he
mentioned you.
I don't think he mentioned my name, but he mentioned the fact that someone had written into him complaining about it.
That's right. He had citizen lawyer was the class that he was teaching, and that's what it was. Okay, so he actually mentioned one of my friends was in his class that semester, and said, I think your dad was talked about. What are you talking about? And he told the story about how the statue was mentioned outside and how someone had written in. He did not believe that we were from the same citizen lawyer we believed that we were, and had this hilarious story. And a couple people knew apparently that it was me and my dad that had caused this controversy of our statue outside. But when we were last there, the name was still present, just as it always was.
So how does the Williamsburg white wine taste?
That's a great question. I'm going to put this back here for us. And I know I love the wine, but let me see if I can describe it. It's good. It's dry. It's
very sophisticated description.
I know, right? Look, I'm an attorney. We had our sommelier on at the beginning of the summer. She was our first session for the Legal Weekly Wine. So catch her. She actually had all the wonderful words. She at least said that my palate was good in terms of the kinds of things I was tasting. So let me see what I can do. It's a drier white. It is very light. It is a light dry. There are not as many fruited flavors as a lot of other white wines have, but it's very crisp. Let me see what the bottle says here as to what's in it. They're saying
if you can read this, thank a teacher.
Right. So it's an American Riesling. So it is a semi-dry, light and fruity Riesling. It's saying the aromas of peach, citrus, and fresh wildflowers. And I can smell those. I can't taste them as well, but enjoy it outdoors and serve with a variety of foods. I would say I think I can, if anything, I'm tasting more of the flowers than of the fruit, but it is dry. It is light and refreshing and would go very well, as it has many times, with a picnic. So that's my plug for the Governor's White. And we have more Williamsburg Winery wines to get through this summer and into the fall. But this one, I've used this one many times. It is quite delightful. It's a staple in our house every time we can go back to the Williamsburg Winery. But thank you. And cheers to you and the Supreme Court for this summer. And your water that will turn into wine.
Exactly.
Okay, so let's do a couple of the other big ones that have come down this last week. We have Groff. Do you want to do the Groff case next?
Sure.
That one's been, that came out the same day as the affirmative action one.
Yeah, so it didn't get quite the attention. But for people that are interested, if they go to the First Amendment Encyclopedia, which is online, I will have I've already submitted the essay. It'll take them a day or two to put some pictures with it. But it's a pretty fascinating case. And what I like about it, and I didn't see this in any of the commentary, but we've been here before in a somewhat different situation. So in the early 19th century, the U.S. Post Office decided that it was going to begin delivering Sunday mail.
Right.
And there was a great controversy throughout the land. Proponents said this would be good for commerce, particularly in rural areas. Right. We want to get information before at the same time that the people in the big city do. Mm-hmm. And we believe in separation of church and state. And the opponents said, we're a Christian nation. And I think actually the argument that they should have made, and that I always found missing and was sort of disappointed
with the original case.
Right. Well, the original controversy in the early 19th century was a time where people were far more likely, I would think, to go to church on Sunday than they are today.
Correct.
And, was it fair to all the people who had Sunday as a day of rest, that they might also be called on for their employers? And what's interesting about this is the side favoring Sunday mail originally prevailed, but by 1840, 45, somewhere along in there, the telegraph came along, and a lot of and railroads were coming in too. A lot of the impetus for the need for Sunday mail fell away. And we
haven't really had Sunday mail. How many
and in fact,
years?
A couple of years ago, there was a discussion of eliminating it on Saturdays, which caused a great furor. But in any case, this Groff case involved in,
and this is hold tight. It's Groff versus DeJoy.
right. Groff was converted, I believe, no, he was an evangelical Christian. And he's been working for the post office, and it wasn't a full-time job. I forget what his specific title, but like a rural carrier. So he sort of filled in extra deliveries for the post office. And the post office decided that it would help, I guess it was Amazon.
Yes.
Amazon decided to go to Sunday deliveries, which this man, by the way, has blocked. He doesn't accept Sunday deliveries from Amazon because he doesn't want other people like himself
to be working,
to have to work on Sunday. So he asked, when he started, they didn't have Sunday delivery. When they started it, he asked to move to another job, which they let him. Then that job also required it, and he didn't show up on Sundays. And I wish I could remember the term, but he received what was called, I think it was called progressive discipline.
That sounds right.
Yeah, which basically means he was given some demerits for not being willing to deliver Sunday mail, and he eventually resigned. And basically, the argument centers on an interpretation of the Title VII of the Civil Rights Act of 1964, which was reaffirmed in 1972. And this law basically said that employers should consider, the religious beliefs and practices of its employees, unless they impose a substantial burden.
Right, the undue burden.
Right, an undue burden on the employer and on the business. But there was a subsequent case in which the court had sort of stuck with this substantial burden, but in passing, they had said something to the effect that it was complicated by seniority. Mm-hmm. It was a case where trying to honor the religious objection or religious beliefs of the person working would have conflicted with labor negotiations that had provided seniority to some. And in those circumstances, the court seemed to imply that all you need is some kind of de minimis effort to meet the employee's wishes. And so in this case, the court said, you found out that it disaccommodated some other people who would also prefer not to work on Sunday, but not for religious reasons. Mm-hmm. The standard of the law is the substantial burden, and you need to go back to that or back to something closer to that. And basically what you have here is there are two clauses in the First Amendment related to religion. Congress shall make no law establishing religion or prohibiting the free exercise thereof.
And those are both in the First Amendment.
They're both in the first, they're at the beginning of the First Amendment. And the decision that the court is clarifying here was concerned that by recognizing by giving them a special consideration for not working on Sunday would somehow be an establishment of religion. This court has put more emphasis on the free exercise of religion.
Right, not prohibiting the free exercise.
It would be hard to say somebody would think you were establishing religion by giving somebody and particularly, now this assumes that if they're Muslim and they're their Sabbath is Friday, or they're Jewish and their Sabbath is Saturday, that you would give them the same consideration as a Christian that you would give on Sunday.
And that seems to be consistent with what the ruling is. It doesn't seem to be, well, just because you're a Christian and you need Sundays, it's a Sunday rule. No. It's a religious rule.
That's right. And what's fascinating about it, well, two things. One is it's a unanimous decision. Now, there is a concurring opinion, but it's unanimous. And the other is that the plaintiffs, the amicus curiae briefs in the case are filed not just by, they're not mainline Protestants. Right. There's a Muslim group. Right. There's Seventh-day Adventists.
There are other religious groups.
Right. I mean, in other words, it doesn't just apply to Sunday taking a day off for worship. It also applies to what you might be wearing. It might apply to, if you need accommodation to wash your feet before you pray twice a day, or have a special room. Right.
Exactly. Allow for prayers where you allow them to pause during certain times of the day to go to pray, to, like you're saying, the special rooms, the specific rooms, to accommodate prayers.
Seems to me that there's a case, and I can't remember if it's one to be decided today or if I'm getting it from a lower court. I think it was on the orders list on Monday, where the court has accepted a case where a person claims he was fired for playing Christian music in his office at the same time that other people were playing, music that I might find offensive.
Right.
So it's
I had one of my supervisors did that. One of my supervisors was extraordinarily religious and fantastically so, in a good way, in a very positive way, but she would have Christian music on and she would leave her door open. And we all were like, oh, well, that's really nice. And, you would go in and listen to the nice ones. And if I thought it was a way for her to keep people out that she didn't like.
Well, that probably would be an impermissible.
I believe she really.
Maybe I should try
it. She genuinely liked the music, but there were certain people in the group who didn't like it.
I need to remember this. Like, you're helping me out here.
It seemed to be very effective for some people not going in. Maybe it was just, one of those side things that just happened to be versus an actual intent, but it was pretty funny to watch. So with this, now here's just some practical questions. And I guess it's because I'm, regularly practicing attorney is, so twofold. One is, did they really need him? Couldn't they just have hired somebody to pick up those Sunday jobs?
That's the question. I mean, the question is, the court is saying you can't just say it would be inconvenient. Mm-hmm. You can't just say, well, it's going to be a little, and one thing you absolutely cannot say that both sides agreed. I mean, the majority and the concurring opinion. Mm-hmm. Said you cannot deny somebody a claim simply because people in the office say Saturday worship, that's ridiculous. Why don't they go to church like the rest of us on Sunday? Or, I can't believe they got to wash their feet before they pray. Right. If it's based on any anti-religious animus, then it's out of bounds no matter what. But, it leaves open, I think, it means you're going to get a lot more of these cases because you're going to have to decide, how far do you have to go in terms of cost, in terms of inconvenience, right. And in terms maybe of, if I didn't go to worship myself on Sunday, would I resent, I would rather maybe have 2 days together, Saturday and Sunday.
Right.
Or Sunday and Monday, then I would have to come in on a Tuesday, have to have to come in for somebody else on a Sunday and then have to take my day off in the week on a Thursday or some other day.
And I wish I had an employment lawyer on with us. And maybe we can on another day, because I don't know the ins. I mean, I know practically because I've been an employee for how long, right? Like we've all been employees. But my question that I don't know the answer to, I don't think these have to be disclosed at time of hiring. And I think some of the employers are getting upset because they're like, well, we didn't know you would have these limitations, so to speak, on your work times, your work days. So should we be allowed to consider that before we hire you?
And I think the answer is no. And I remember a distinct situation where your mother was asked when she took her first job whether she could go a year without getting pregnant. And that was totally, was totally illegal.
Now
even at the time. I mean, this is 40, 50 years ago. It was illegal then. It's still illegal. And I don't know if that's an exact parallel, but, if we do accommodate people for childcare, pregnancy, other things, then it does seem that you might give at least as, similar consideration to questions of religious. Now again, does it mean that a company would have to go bankrupt because, it's pledged that it's going to be open on Sunday and none of its employees would do so? Probably not. I would hope not. But, it's saying, it's trying to put religion back in the prominence that it had. We're guaranteed religious extra. And now do note, of course, this is a government employment,
not private.
And there may be different, there may be different considerations, partly depending on the size of the business. Is it engaged in interstate commerce and whatever?
Well, but that also goes to how much of a hardship is it?
Right.
For the private versus the public.
Right. Anyway, it's a fascinating case. It's hard to say the court doesn't get it right when they do it unanimously. And there's so much talk. I'm trying to work on an article that's, what do I have the title of it? I don't know if it'll get published, but all I want is a normal court. Which I go through. All I want is a court that will follow precedents when I agree with them. Overturn them when I don't. All I want is a court that has a majority of people from my political party. All I want is a court that will strike down presidential executive orders that are bad and uphold those that are good. And one of the things that really troubles me about both sides, and we're so predictable. What do you think of the court today? Well, what did they do for me today? And by me, I mean, did they agree with me or my positions or not? And if they agree with me, the court's great. And if they disagree with me, the country's going to hell in a handbasket.
Exactly.
We need to sack the court. We need to do this. We need to do that. My hope is, and they do. We tell them to be nonpartisan, but we run them through this gauntlet, right?
Exactly.
We try to get all these pledges from them, and then we're surprised that the court, sometimes acts in what seems to be a partisan fashion.
Right. Goodness. Okay, so let's get at least one other case in. We could talk about so many, but let's at least talk about the threats case. And let me make sure I'm getting the right name.
Yeah, it's a contrarian. It's let's see, Counterman. I love the name. Counterman versus Colorado.
Okay, good. You've got that. For some reason, mine.
Yeah, and it's a very, I'm not sure that I think the court got it right. I'll just be honest with you.
Okay.
Essentially.
That's good to know at the start of it.
Right. And again, I mean, I do understand. Truthfully, I think when the case is retried, that the man is still going to be convicted.
And tell us what he was originally convicted of.
Well, he's convicted. He's actually indicted under a stalking charge, as I understand it.
Correct.
And then the legal issue here is something known as true threats. So one of the exceptions to the First Amendment is you cannot use speech to extort, to bribe, or to put someone in fear of their life. Basically to assault, I guess would be the legal term, right? Assault and battery. You can't use. Okay, I've lost your audio.
Harm.
I just lost your. I heard the last of it, but not the first of it.
Yeah, assault is generally that you're putting someone in reasonable apprehension of immediate harm.
Right, and so here he had been convicted. He is, and this is a woman. He goes after a woman, a musician who apparently he's never met, and starts dissing her. Which I guess he has the right, it's not, but it's not
There's
just
so many haters.
It's like, I hope you die, that sort of thing. He indicated that he knew what kind of car she drove and where she lived, and maybe was following her around. And the court said, this fits that definition of a true threat.
Right.
And what he said is, well, they didn't prove that I actually intended to threaten. They didn't all they did was look at what I said, and they didn't ask me, well, what did you mean by that?
Right.
And there's another case, and I wish that I could remember the name, but there's a similar case out there a year or so ago involving something. Right, where somebody is writing rap music, and he basically, wishes for the death of his former wife or whatever, and so it's partly related to that case. To what degree? Basically, what the court said is that you have to prove some subjective. Now, it was sort of proven that he had said this. Mm-hmm. But it wasn't as clear. Well, what did he mean by it? Did he mean it as a subject? So they added. The court was using a purely objective test, and the court said, no, you got to look at least. You have to have mens rea to have a criminal intent. Right, criminal intent, and the court hadn't actually proven that. Now, again, so the court sent it back and said, if you want to try this guy, here's what you have to prove. I think they're going to be able to prove it. Yeah,
it seems to be the normal assault is, would a reasonable person understand his statements as threats? Would these statements put a reasonable person in
right? And that's the sort of objective test, and the court is saying, you got to go a little bit beyond that, and you have to determine, well, what was his, did he, now, again.
Well, that's the dissent, is Clarence Thomas and Amy Coney Barrett are saying that it required some kind of subjective knowledge, that he had to specifically intend them to be a threat. But in a regular court, and to me, this doesn't seem so significant. And, as a prosecutor, former criminal defense attorney too, like I've done both sides. And in the end, it just seems to kind of be the same as it used to be. It doesn't seem to be any major implication on continuing law, where I have to prove through even circumstantial evidence, he can get up there and say all day long, well, I didn't mean them as a threat. But you have the right as a juror to look at them and say, well, with all of the language that you used, with the way that you did it, with the information that you have, we can reasonably interpret that you really did mean it as a threat. Just like any defendant, a defendant in a murder trial can get up and say, I didn't do it. But that doesn't require you to believe that.
I think the difference is it's a little harder maybe to assess threats on the internet than it is face to face.
And that's the difference in this case, is it was
Right.
an internet case versus anything else, which is rather novel for the court.
Right. Pretty fascinating case.
It is. All right. So I know that more cases have been coming down today. And I know it's sad to actually put those on hold for next week. But what ones do we have coming up that will be next week that we will recap?
Well, I had them written down here somewhere. We have a case involving another religious freedom versus LGBT. To what degree does a wedding planner have to, serve, or should they be required to serve LGBT plus community? And then something that will be of interest to many of your viewers, I'm sure, Biden's executive order regarding loan repayment. Does he have the authority to suspend these by executive order? And of course, in the meantime, we do need to remember we will be celebrating on July 4th, the 247th. Is that right?
I think that's right. You're better with the numbers.
Anniversary of the United States. I don't know if you can see my tie, but I have a nice little tie there to celebrate the occasion. Gave a speech on the subject yesterday. Times have changed. In early America, every 4th of July. Now there were parades and whatever, but the price was always a 1 to 2 hour or longer speech on the founding fathers and the 4th of July.
Sure.
Today we pretty much dispense with speech making.
Yeah.
And focus on the fireworks and the picnics.
Eat some burgers.
Yes.
And hot dogs. Yeah. Okay. So what I'm glad you mentioned that, because what we are going to do is because we have Dr. Vial this summer and we have he's generously given us his time, we would like to do, especially since he knows so much more about the founding fathers and our original Constitution and Declaration, is we're going to do a special weekly wine for the 4th. So join us for that. We'll get it out either on the 4th or on the 5th, but through the 4th. And we would love to have you join us for a talk about the founding, about the Declaration, and whatever else Dr. Vial is happy to let us know. It will not be a full speech. We will have conversation, a little bit of back and forth. So you don't.
You just lost your audience, or maybe you gained a few back. You are about to. Everybody suddenly signs off.
Well, join us for happy hour. Join us for a celebration of the 4th and of our country, of our founding, and how far or how little you believe that we've come since then. But happy hour today.
Just a teaser.
Yes. Ooh.
Just a teaser.
Ooh, tell us.
John Adams was convinced that we would be celebrating Independence Day on July 2nd. And if your readers don't know why, or listeners don't know why, they need to know. And if they don't know which 3 presidents died on the 4th and which president was born on the 4th, they'll also get to learn that.
Oh, I love it. Those are great teasers. Yes. Don't give it away now. We have to have them watch on the 4th.
Okay.
So yes, I love those teasers, and thank you. Hope you've had a wonderful happy hour here on the last Friday of June. Stay tuned with us for next Friday, where we review the court's decisions from today, and next week for our special edition for the 4th of July. I'm Virginia Tehrani, and this is Dr. John Vial. And thank you for joining us here on the Legal Weekly Wine.